each category, as a result whereof petitioner was thrown out of contention and is treated under general category candidate.
May I take 2 minutes to explain the situation?
Yes.
If it is, section 34 requires us to have 4% reservation under the 2016 Act, which was 3% in the 1995 Act. Section 34 categorizes these 4% where it is to be allocated. In exercise of that power under section 34 subsection 1, this notification which has been handed over by the commission has been made. Now, my lord, your lordship will find in that the 12th point is for the persons with blindness and low vision. My lord, I'll request your lordship, my lord, to read this notification, gazette notification, along with page 80. My lord, it will be easier for me to explain. My lord, kindly takes page 80 side by side. My lord, kindly take serial number 6 at page 80. My lord, serial number 6 is PHVH, that is visually handicapped. My lord, your lordship will find the corresponding entry at 12 vacancy.
What is VH?
Visually handicapped. That is
physically handicapped, or
PHVH, physically handicapped, visually handicapped. Well, that the corresponding, the roster point is the 12th vacancy in the gazette notification which I have handed over.
Unreserved persons with disabilities,
blindness and low vision. Now, my lord, kindly takes serial number 7 at page 80, that is PHHI, that is hearing impaired. Hearing impaired, your lordship will find at the roster point number 42. Deaf and hard of hearing. This is hearing impaired. Then your lordship will find serial number 8 at page 80. PHOH. This OH is being entire foundation of the writ petition is that O means orthopedic. But OH is other disability. Your lordship will find at vacancy point number 72. That is persons with disabilities, autism, intellectual disability, specific learning disability, mental illness, and multiple disabilities. These are OH. Then, my lord, serial number 9. Other disabilities. Because, my lord, all this cannot be made a short form, so other disabilities. This is what was added in the 2016 Act.
72nd vacancy is required to be reserved for PHOH. Then why? Because there are vacancies under 100-point roster, much more than 72 vacancies.
Yes.
So why there is no categorization under PHOH identifying 72nd vacancy?
72nd vacancy is PHOH.
PH. So in this case, you are submitting. He is submitting that there is no vacancy under PHOH.
Under. I'll come back. If I may answer only after showing serial number 9.
Contention.
But kindly take serial number 9 that answers the question. Serial number 9 kindly takes PHLD. PHLD is the roster point number 32. That is locomotor disability. Kindly takes in the notification 32nd vacancy point.
Locomotor disability.
Right. Now, my lord, why my learned friend is saying that there is no vacancy as the petitioner wants, because kindly sees the 32nd vacancy is scheduled caste. It is not unreserved, unlike 12, 42 and 72. Therefore, when the petitioner is applying under OH, petitioner is not belonging to OH category. Petitioner is belonging to LD category.
According to you, petitioner applied as PHOH.
But he was LD.
It is persons with disabilities, autism, intellectual disabilities. These are the disabilities.
Yes.
It is 72nd vacancy.
But he is not under that. He is not under the category of autism, intellectual disability, specific learning disability, mental illness, and multiple disability. He is coming under locomotor disability. Therefore, he will fall under.
So, petitioner is not a candidate under PHOH.
No. That is why at the time of verification.
What is the categorization of the subcategorization under so far petitioner is confirmed?
LD. But that is reserved for SC, which your lordship will find at page 80, serial number 9.
PHLD is 42nd vacancy.
Yes.
42nd
No,
vacancy.
30 seconds.
Locomotor disability.
Yes.
So that is scheduled caste candidate. That is for scheduled caste candidate.
Yes. Malad,
Petitioner is
we'll
not-
kindly keep scheduled caste at the side for the time being. Keep it
So
aside.
petitioner is not a scheduled caste category.
First question is whether the petitioner is OH or not. Malad, by the O, every petitioner will, every person, applicant, Malad, I'm sorry for using the word petitioner, every candidate will interpret O as their, someone will say it is ocular handicapped, someone might say it is orthopedically handicapped. But that is, question is whether the petitioner is OH or not. Whether it is SC or not, that is the secondary question.
Where is the disability certificate?
Petitioner disability certificate. Malad,
Where is the
petitioner
disability certificate?
43.
You are treating the petitioner as PHLD, locomotor disability.
Malad,
Yes, lower limb.
Malad, paragraph
Disabled and has got mild, weak, then mild, weak of right lower limb.
right limb.
But what is there after weak? I can't read.
Malad, it will be Malad.
Mild, weak.
Your lordship may take the pleading and paragraph 3. Malad, that will clear any doubt.
It is PHLD, locomotor disability. Weak, right limb, lower limb. RL, lower limb. So it is locomotor disability.
43 first paragraph, considered as orthopedically disability.
Right. So he is not autism.
That's true.
So it's not coming under other disabilities.
That melody that I was first SLST, I was recommended at PHOH.
Forget about first SLST.
As per the decision of the Supreme Court, that vacancy has been advertised. I tell you,
Court has to consider the present position. On the anvil of 2016 Act, Disabilities Act of 2016. Now in 2016 Act, if there is subcategorization and there is a notification issued by the state government, then in that event, yes, you are a disabled candidate, you are differently abled candidate, but your categorization comes, your category comes under PHLD. If it is PHLD, then you are then the vacancy should be 32nd vacancy, which is reserved for scheduled caste candidate. Applying 100-point roster.
Melody page 71, I applied online category PHOH. I don't know, Melody, this is the 2019 notification. Prior to the judgment of the, prior to the notification,
So
2016 rules, 2025 rules. 2025 rules, Melody, category has been defined. Your lordship, Melody, kindly 71, your lordship online application.
But when the persons were applying, I'm sorry to interrupt my learned friend.
Regarding
But there was no
categorization of
doubt.
vacancy,
Kindly switch.
identification of vacancy, I in Sanjay Dolui, I delivered a judgment which was upheld right up to Supreme Court. It was not interfered with.
But in the
So therefore, court will not embark upon this categorization again. Now, if this is a notification of 8 July 2019, if you do not come under the category of PHOH, then the vacancy that is PHOL, if you come under that category, then it will be a 32nd vacancy. 32nd vacancy is reserved under 100-point roster is reserved for scheduled caste candidate. You are a general category candidate.
Well, at the time of selecting the option, I have handed over.
This is your disability certificate. It is not keep a copy of this notification if you have. Yes, come to the categorization. It is 2019 notification, much before initiation of selection process of 2025, and 72nd vacancy unreserved persons with disability, autism, intellectual disability, special learning disability, mental illness, and multiple disabilities. You are not coming under this.
but the
Considering your disability certificate.
but the online application, verification, merit
There
list,
is a statement made in the writ petition regarding the nature of
Para
disability,
3.
which petitioner is suffering.
Para 3. Second line.
Being orthopedically disabled.
That's true, orthopedically disability, but the notifications reflects, my lord, after the 2025 rules, my lord, the commission, my lord, submitted, my lord, appointment, issued appointment notification, prescribed my lord, the inviting application from the candidate from
How many vacancies are there?
6.
Under PH
LD. 6.
6 vacancies. So if there are 6 vacancies, then first vacancy will be 32nd vacancy.
No. No, my lord, under PH there are 25 in mathematics PG. Out of that 25, 7 are under roster point 12. 6 each under 32, 42 and 72.
7 under roster point
12. Then 32, 42 and 72, there are 6 each. Because when the roster point is calculated, it completes a full circle up to 100, then goes back to 1.
Yes.
Then again, it comes to 100, then goes back to 1. It like that.
Rotation.
Rotation. Yes. By rotation, it has stopped somewhere between 12 and 32. So 12 has got 7, 32 has got 6, 42 has got 6, 72 has got 6. In the next round, whenever it's the next SLST, it will start from the point where it has stopped now. It will start from there. If it has stopped at 15 or 16, it will start from 16 or 17 in the next round.
So by applying rotation and applying 100-point roster, so there are total 12 vacancies.
25 under PH.
Under PH. Now for PH LD, how many vacancies are there? 6. So within first 100 there will be 32nd. 32nd. In the second 100 again 1. So by doing, there are 6 vacancies under PH
OH,
LD. So if it is if 6 round is completed, in that event this 32nd vacancy in the 6th round will be reserved for PH LD.
Yes.
Now suppose if in the 5th round it comes to an end, process comes to an end, then how the 6th vacancy will be accommodated under PH LD?
How
if it is counted up to 532,
yes,
then 6 vacancies can be accommodated.
It will end at 32.
If this while rounding up or while rotating, applying 100-point roster, if the process ends at 510, says 510,
yes,
then how 6th vacancy under PH LD will be accommodated?
It will not be. It will not be. And it will not be required also. I'll tell you, Lordship, why. Because by the time we reach 510, we will have, for each 100, we will have 4 PH. 4 PH in the first 100.
500, 3 PH.
So we'll get 20 PH. So 4% is the requirement under the Act. For 510, 4% is 20 point something. So we'll have 20. So the mandate of section 34 will be satisfied. In the next round, whenever is the next round, maybe say SLST 2030, the roster point will be start counting from the 11th point.
So considering the number of vacancies, 100-point roster applies. Where it ends. While
now, Malad, I'll give
at the end point, say if it is up to 510, in that event there will be 4 vacancies in first 100. Then another 4 vacancies in second 100. By doing this up to 500, there will be 5 into 4.
Yes.
20 vacancies will be
there. Which is 4% of 510. Now, Malad, kindly takes a different example.
4 multiplied by 5.
Yes. Malad, kindly
it comes to 20 vacancies.
Kindly takes a different example. Only 25 vacancies have been advertised. Only 25. In that case, you start at 1, end at 25. So there will be only 1, that is only 12 vacancies.
12 vacancies.
If it starts from 1, if it starts from some other number, some other vacancy will be there. Now 4% of 25 is again 1.
Yes.
Well, the page 79, I'll tell you, page 79, this has been published preliminary list for interview. Page 79A, my lord, my
Now,
last friend, my lord, showing-
one thing is also troubling this courts of, it is a case of PHLD, locomotor disability. If it is locomotor disability, then it is 32nd vacancy. So all locomotor disability vacancies will be reserved for civil caste candidate.
Yes. Because my lord, scheduled caste, scheduled tribe, and OBC, my lord, these are flowing out of 16.4, Article 16.4. These are all vertical. Other horizontal vacancies, my lord, flow out of Article 14, Article 15. Those are not class-based reservation. Those are horizontal reservations, my lord. The vertical reservations, when it is interlocking with horizontal reservation, my lord, the word used by the Honorable Supreme Court is inviolable. My lord, the vertical reservation flowing out of 16.4 cannot be violated. It is free from violation.
But if it is so, then if there are 500 vacancies, all the 32nd vacancies will be reserved for civil caste candidates.
Yes.
So a candidate
Who is unreserved?
general category PHOL candidate, or
LD.
PHLD candidate will never be considered as
My lord,
as a reserved category candidate.
I'll tell you, Lordship, my lord. There are two answers to it, my lord. First of all, if there is no SC candidate, my lord, first of all, it can be de-reserved. Number one. Number two, my lord, again going back to that argument, vertical reservation flowing out of Article 16.4 is not interchangeable. But horizontal reservation flowing out of Article 14 and Article 15 are interchangeable. Though, my lord, if required to accommodate, my lord, it is interchangeably, it can be accommodated.
But there is a fallacy in it.
But my lord, my lord,
if a candidate comes under the category of PHLD and he's a general category candidate, he will never be considered as
in the first round, no.
Yes.
In the first round, before de-reservation or interchanging, he will not be considered. But I will, my lord, request your lordship, my lord, not to go into that question in this writ petition. Because my lord,
this is not under challenge.
Yes, because the basis is not under challenge. The foundation of this petition is that O means orthopedic. Well, I can satisfy your lordship, my lord, on that point, my lord. We had a rough idea that these questions will come. We have also come prepared with on that point. But my lord, the prayers will not justify
But
going
it
into that
doesn't
point.
make sense. Always 30
But it will, my lord. If I address your lordship, my lord,
reserved for physically handicapped. So then what would be the fate of a physically handicapped locomotive LD candidate
general.
who is general?
But it will make sense, my lord.
Interesting
No,
point.
but it will make sense, my lord, if I address your lordship, my lord, on this aspect, my lord, because this has been dealt with. This has been dealt with by our courts, my lord, starting from Indraswamy onwards, my lord. Even recent judgments are there. There is RBI versus AK Nair. There is one of the most recent judgments, my lord. Yes, 4th July 2023, my lord. Now, my lord, I can satisfy your lordship on that point, and I'm prepared, my lord, on that point. But question is that whether the prayers justify going into that point in this matter or not.
Because very basis of the writ petition is
Paragraph 3.
Physically
That I am orthopedically disabled, that means I am OH.
differently abled, orthopedically disabled.
Which he could not ultimately justify that he is OH.
79A. My lord, that has not been, my lord, spelled out, my lord, by your lordship kindly see, that has not been stated.
That is a remarks column.
No. Category has been changed.
Yes, I'll tell you why.
Commission issued a notification for edit of the category. My lord, he did not, my lord, edit, my lord, his category, my lord, within time. My lord, now the Honorable Division Bench yesterday delivered a judgment that yesterday 6 p.m. to today 6 p.m. all, my lord, the reserve category has been given opportunity to upload their, my lord, the category. I have also successfully uploaded his category.
No, but here the case is
that has not been.
That though you came, you participated, you were shortlisted, but ultimately it appears that your category is under PH.
That is first time, my lord, they produced the notification.
No. I have handed over a document. Kindly see the categorization single page. Malad, that single page, Malad. This I have handed.
It's not appearing 79A. Your lordship kindly see. They said what this category has been changed. Also rules, my lord, that has not been stated, mentioned, my lord, in the rules. notification.
In the
that PH
in the application, was there any indication that anybody can appear under PH, LD or PH?
It is there in the advertisement that how many posts are being advertised, my lord.
Yes, under physically handicapped PH category, whether there was an indication of subcategorization in the advertisement, or a candidate having physical valid disability certificate can apply under PH category without mentioning subcategorization. Where is the application form?
A candidate also I did not apply
My lord,
because I am physically handicapped.
page 76 kindly sees. Page 76.
Because I did not
Just a
apply.
minute.
No. He is applying under OH. He is giving a disability certificate of LD. Therefore, my lord, when it is not at the verification,
Page 71, your application says application fees SC, ST, PH.
PH. That is for the fees.
In broader
proposal,
respect, it
kindly
only
seek 76.
No, category, page 71, category just 3 or 4 before my lord, that category PHOH.
that you have filled up.
I have filled up.
So at the verification, he cannot.
Candidate under PHOH.
OH means other handicap.
Yes.
Handicap, my lord, I was appointee, I W just, my lord, under the
No, at the time of submitting this application, whether you had any opportunity to apply under PH OL.
হতে পারে না কারণ এখানে OH এর অপশন আছে
PH LD, not OL.
এখানে
PH LD.
OH এর অপশন আছে মানে LD এর অপশন থাকবে না কিন্তু এই কথাটা লেখা ছিল কিনা দেখতে
category PHOH. That is why, my lord, I have given.
Mr. Bandyopadhyay, if in the at the time of making application there was no option other than PHOH, how petitioner can apply?
It is impossible, my lord. What the petitioner is submitting, then everyone has to make an option of OH. There was an option of similar to what the petitioner has filled up. There was VH also, there was HI also, there was LD also.
These options were there.
Yes. Otherwise, how? I asked this question to myself: how he chose OH, and why he chose OH? He has chosen OH on the basis of his misconception that OH means orthopedically handicapped.
That could not have been published. Result was published page 76.
Correct, because
I got the
result is before verification. Result is before verification.
So, according to the respondents, this at the time of submitting online application, this
option was there and he has chosen OH. Yes.
PHOH and result was published page 79. I could have, my lord, commission could have, my lord, disclosed, my lord, the result at the time of publishing result that no, you are not PHOH. Page 76. Thereafter list has been published. I can, my lord, apply, my lord, the change of category under the PH to OBCA.
My lord, it seems that he has edited also his option once.
After the notification.
Because my lord, the last date of application was 21st July. Right? 21st of July. Kindly see page 72 when this page 71 has been printed. Page 72 kindly sees. 72 bottom kindly sees. 29th August he has printed it. This is the time when the edit option was there. So he has edited it to PHOH.
Where?
No.
But at the bottom of 72. Middle bottom.
Page 72.
72 in the fine print generated on Friday, August 29, 19:15 hours.
Yes, 19:15 hours.
So this is much after the last date of.
What is this document?
So this is his application
Academic
form.
qualification.
His application form, which he has edited also, out of his own volition.
I do not understand.
I am understanding that you could have generated this on August 29 after almost 1 month of the last date of application because you have availed the facility of editing the category. The commission allowed everyone to edit their option.
Why, my lord,
But merely because the petitioner has wrongly given his category, he has not obtained any right to challenge the process.
No, this, my lord, I could not, my lord, the change of edit, my lord, my change of category.
Then how could he print it on 29th of August?
That is the printed, my lord, after the 29th August 20.
Generated. It's not just printed.
Generated, yes. So generated on 29th of August.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop.
And just before that, my lord, I am a OBC A category. my lord, the OBC candidate, my lord, I did not apply because I applied, my lord, the under PhD.
Matter is heard in presence of the learned advocates representing the petitioner, state respondents, and West Bengal Central School Service Commission, for short commission, quote unquote, close bracket. Next slide. Learned advocate representing the petitioner. Participated in second state level selection test 2025 for being appointed as an assistant teacher of mathematics for classes 11 and 12. Stop. Petitioner applied under. Now, petitioner applied by submitting online application declaring himself as differently able candidate under which is other handicap category. Other handicap other handicap within bracket PH wage close bracket category. Stop. Petitioner participated in the selection process. Petitioner participated in the written test and under PH category, and initially petitioner was treated as a PH category candidate who was awarded 70 marks, whereas under PH category cutoff marks was fixed 55. Top. Reliance is also placed on a document at page 77 of the writ petition, wherefrom it appears that validity of disability certificate of the petitioner was accepted by the commission. Stop. Next paragraph. Grievance of the petitioner is
Not that I know.
while preparing a list of candidates for participation in ensuing personality test, instead of PH wage category, he was considered under general category male. As a result whereof, petitioner was not found eligible to participate in personality test. Stop. It appears from page 79, capital A of the writ petition. Under general category, 71 was fixed as cut-off marks for participation in personality test, whereas petitioner obtained 70. Stop. Next paragraph, it is contended that petitioner ought not to have been treated as general category candidate while considering candidature of the petitioner for participation
to accept the argument of Mr. Kaur
personality.
after extending
Yes.
benefits of
Stop.
the regular teacher to the said 313 volunteer teachers now cannot turn back and say the approval of regularization.
Prayer is made. Now, next paragraph. Case is made out in the writ petition that petitioner is orthopedically handicapped, therefore he should have been considered as differently abled candidate, and considering marks awarded to him, that is i.e. 50, that is 70, he is required to be given opportunity to participate in ensuing personality test as under PH category. Cut-off marks fixed is 50. Next paragraph. Learned advocates, Mr. Bandopad, Mr. Shishano Bandopad, learned senior standing counsel representing state respondents, submits that petitioner applied under physically handicapped as well as orthopedically handicapped candidate, which comes under subclassification PHLD, having locomotor disability. In this regard, attention of this court has been drawn to the statements made in paragraph 3 of the writ petition, wherein it is averred that petitioner is orthopedically disabled. Stop. Another limb of submission made on behalf of state respondents is based on order dated 8 July 2019, issued by Chief Secretary to the Government of West Bengal under Section 34 within bracket 1 of Rights of Persons with Disabilities Act 1961.
2016.
Rights of Disabilities Act 2016, which prescribes 2016. Stop. As per order dated 8 July 2019, as per said order dated, stop. Copy of the said order is placed before this court and same is taken out. As per said order dated 8 July 2019, applying 100% roster at the time of identifying vacancies. 30-second vacancy needs to be earmarked for scheduled caste candidate who comes under persons with disabilities hyphen locomotor disability including cerebral palsy, leprosy cured, dwarfism, acid attack, victims and muscular dystrophy. Stop. Under clause 2 of said government order dated 8 July 2019, 72nd vacancy is classified, or 72nd vacancy is earmarked for unreserved category candidate having other disabilities, that is autism, intellectual disability, specific learning disability, mental illness and multiple disabilities. Stop. It is submitted considering the case made out in the writ petition. Petitioner ought not to be treated as PHOH candidate. Rather, petitioner is required to be treated under PHLD candidate, as it is described under clause 2 within bracket small b of the said order dated 8 July 2019. Stop. As it is further contended as, next paragraph, it is further contended as 32nd vacancy is to be reserved for physically handicapped and physically handicapped candidate having locomotor disability. And in paragraph 3 of the writ petition, petitioner declared himself as a person being orthopedically disabled. He is not entitled to get the benefit of such reservation. Under 32nd vacancy as envisaged under order dated 8 July 2019, as the petitioner comes under general category. Stop. Therefore, according to the respondents or respondent authorities, according to respondent authorities, petitioner was treated as general category candidate, but considering the marks awarded to the petitioner, that is 70, he did not come within the zone of consideration. Next paragraph. Next paragraph, learned advocate representing commission reiterates the submission made on behalf of the state respondents. Next paragraph. Having considered the respective submissions made on behalf of the parties and case made out in this writ petition, court is required to consider the prayer of the petitioner, or court is required to consider the prayer of the petitioner on the anvil of order dated 8 July 2019, issued by the Chief Secretary to the Government of West Bengal, Labor Department, Chief Secretary to the Government of West Bengal. Stop. Government of West Bengal within bracket Labor Department. Stop. It is specified under clause 2 of Government order dated 8 July 2019 that 32nd vacancy is reserved for locomotory disabled candidate, or is reserved for disabled candidate having locomotor is reserved for a candidate having locomotor disability and applying 100-point roster if the said vacancy is 32nd. In that event, it is reserved for scheduled caste candidate. Had the petitioner been considered as disabled candidate having other disabilities as specified under clause 2 within bracket D, then candidature of the petitioner could have been considered against 72nd vacancy, which is reserved for general category candidate. Stop. However, there is no dispute relating to nature of disability of the petitioner based on averments made in paragraph 3 of the writ petition that petitioner is orthopedically handicapped. In addition thereto, disability certificate is attached at page 43 of the writ petition, wherefrom it appears that petitioner had a deformity in lower limb, which corroborates the statements made in paragraph 3 of the writ petition relating to nature of disability. Stop. Next paragraph. Therefore, court needs to proceed on the premise that petitioner can be accommodated against 32nd vacancy, applying 100-point roster, which is reserved for differently able candidate having locomotor disability, and said vacancy having locomotor disability. Stop. Admittedly, petitioner is general category candidate. Therefore, his candidature cannot be considered against 32nd vacancy. Stop. As a result, stop. Stop the কেটে দাও. As a result whereof, petitioner was treated as general category candidate to accommodate him in the ensuing personality test, but considering the marks awarded to the marks obtained by the petitioner, he did not come within the zone of consideration. As he did not come within the zone of consideration. Stop. Petitioner obtained 70, whereas under general category cutoff marks was fixed 71. Next paragraph. Before parting with, it appears that clause 2 of the order dated 8 July 2019 prescribed reservation of reservation of a post against 32nd vacancy, which needs to be reserved for scheduled caste candidate having locomotor disability or other disabilities described in clause 2 within bracket B. Stop. If clause 2 within bracket B is applied, in that event a situation will crop up where only scheduled caste candidate having locomotor disability or other disabilities defined therein will get opportunity of reservation under PH category, denying the right of general category candidates or other category candidates having locomotor disabilities, having specified disabilities under clause 2B to be considered against said specified vacancy. Stop. However, such consideration in the present case is purely academic, as no case is made out in this writ petition. Rather, in paragraph 3, it is averred that petitioner is orthopedically handicapped. Next paragraph. In aforesaid conspectus, writ petition stands dismissed. However, there shall be no orders to post urgent. Point is kept to.
But serial number 4 takes care of it, but it requires a bit of hearing on that point.
Only one thing, my lord, the stated, my lord, the petitioner is a unattended teachers, my lord, of first SLS. Your lordship.
So if he is unattended teacher, he has got a
He will continue till the Honorable Supreme Court has given the timelines, and thereafter his fate will be determined by this selection process. The Honorable Supreme Court has not directed all unattended candidates to be continued for permanent.
Saying that I'm saying that there will be the statement that he is an unattended teachers under first SLS students. Because he was appointed under PHOH. He is a teachers, মানে approved teachers.
ওর যেখানে সাবমিশনটা মিস্টার জানার রেকর্ড করা আছে ওখানে শেষে একটা দিয়ে দেবে it is also submitted that petitioner is an untainted candidate who got appointment in connection with first state level selection test 2016 for classes 11 and 12.
11.
For classes 11 and 12, and he is working as an assistant teacher at present.
And under PHOH category, he was appointed. That has been mentioned in the recommendation approval.
Stop. Yes, next one. Wait for me. Two.
Pursuant to lordship direction of submitting the deficit court fees, my lord.
It was filed on Yes.
I'm appearing for the statement laid by learned Advocate General.
But in this matter, the petitioners are concerned, they are all BSc pass male candidate. And my lord, they have been shut
BSc pass?
BSc pass.
BSc.
BSc.
Public Service Commission.
Yeah, no.
Yes.
BSc.
BSc.
BSc. Bachelor of Science. My lord. My lord, they are all male candidates, my lord, who has been shut out by subsequent to an amendment came into the effect of 2018. 2015, there is a provision, there is no indication of male and female, but 2018 is concerned, my lord, there is a clear indication that BSc female candidate has been given priority, and rather
where priority is given?
In the government of West Bengal, those who are want to serve their service as a nurse, there I will not get any chance as a male candidates. But my lord, kindly
what is the challenge? Let me see.
That is the challenge, that amendment.
So there is no scope for passing any interim order at this stage because you have challenged
Because there is a
challenge sub-rule 2 of the West Bengal Nursing Personnel Recruitment Rules 2015.
Prior to that, my lord, I have filed one public interest litigation. Wrongly, it was stated in service matter, it will not lie. Then there was an advertisement. Subsequent to that, 2025, another advertisement for those female candidates are concerned has been given. So there I also going to lose my chance.
2015 rules.
Yes, well, that's the, I mean, now they are following the 2018.
Nursing rules, recruitment rules of 2015.
Yes. And next page, my lord, that is at page 204. Volume 2.
Which rule you have challenged?
204. Page 204.
So it was given effect to Vide Gazette notification dated 27th April 2018.
My lord.
My lord.
So therefore, already 7 years have passed in the
My
meantime.
lord.
There is no scope for passing any interim
No,
order.
I am only before your lordship that I may or may not get chance subject to the policy of the government. It is one aspect. But so far 2025, what is going on, there is also I am losing my chance.
What can be done?
Their policy.
But unless until the virus of this rule is decided, there is no
That's
scope.
true, my lord. That's true.
Yes, sure.
That's true.
In the writ petition, you have specifically challenged rule 2, sub-rule 2. Sub-rule 2 under which rule?
Rule
I think, my lord,
Fine.
amended portion.
amended, but there is a page 204, volume 2, 204, page 204.
Yes, 204.
Now, this is said the age between, well, may I place in also? Well, age between 18 years to 39.
In the said rule in rule 5.
Well,
So it is amended rule 5 2.
Rule 5.
In the writ petition, amended rule 5 within sub-rule 2. Sub-rule 2. Which was brought into effect with a Gazette notification dated 27th April 2018. একবার সেন্টেন্সটা পড়ো তো না rule 2 of West Bengal nursing personnel within bracket recruitment close bracket rules 2015, which was brought into effect with a Gazette notification dated 27th April 2018 is questioned. Stop. Petitioners are aggrieved by
Now, kindly indicate the male candidates, my lord.
preference given
Well.
in favor of female candidates
in staff nurse, my lord.
Grade 2.
Recruitment of staff nurse, grade 2. That is at, my lord. It will be clear, my lord, 202, if you lordship see 202. Clause 4, staff nurse, grade 2.
clause 4 of
202, my lord.
202, my lord. Page 202, clause 4, post has been mentioned. Staff nurse, grade 2.
is a method of recruitment. Just a minute.
Post, my lord.
Post, my lord.
This is the post.
Roman 1.
Name of the post.
Staff nurse grade 2
Right.
in recruitment of staff কি বলছিলাম in recruitment of staff nurse grade 2. Stop. Next paragraph. Next, state respondents are represented by learned advocates. Stop. Considering the issue involved in this writ petition and the nature of challenge thrown to a particular provision as amended vide Gazette notification dated 27th April 2018. There is no scope for passing an interim order. Stop. Issue, no, stop. Issue needs to be decided after calling for affidavits. Next paragraph, let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing Christmas vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter.
1 week.
By 1 week thereafter. Next paragraph. Petitioners shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
When I'm praying for leave to file one supplementary affidavit in the annexure portion, I read it wrong. That is, but P1, P2 I have referred, but annexure I mentioned A.
The supplementary affidavit filed on behalf of the petitioners is taken on.
The copy has been served up in the state. I'm grateful.
In one matter, I have requested learned advocate general to appear.
Yes, my lord. Yes, my lord.
Yes, no. Because there are no benches under West Bengal Administrative Tribunal. Now the litigants are coming directly before this court, which prima facie court has expressed view that if tribunal is not available in consideration of L. Chandrakumar, litigants or the petitioners are required to approach the Honorable Division Bench, not before the single bench of High Court. Now, the present judgment of Rogers judgment is being relied upon. It's a 5-bench judgment. So, tell Mr. Advocate General to appear on a particular date where
probably it will be taken
after
up
vacation. After vacation. Okay. Probably on 6th.
6th.
I'm grateful to know.
If in the meantime appointments are made, issue will be diluted.
Yes,
tribunal. Otherwise, court has to consider.
Considering that issue also, if there is only one member and the party will, my lord, give consent, they can move the.
Now they are submitting. There is no members. Yes.
Item number 3.
For the respondents, madam. Petitioner, as per your lordship's direction, I have served to the respondent number 6 an affidavit of service. They have received.
Yes. What is the present position?
My lord, 2, my lord, verification is required. One is from my lord.
Have you obtained any?
Yes, my lord. Yes, my lord. One is from the Director Central Fingerprint Bureau. That is respondent number 6.
That you have obtained.
That I have obtained. Then we have sent to the my lord respondent number 4 before my lord the Central Forensic my lord, Laboratory for my lord verification of the my lord fingerprints, my lord. So my lord, if you lord please, my lord these are my lord, I can show to lord the instruction here, my lord, on 22nd on my lord 2nd February 2nd December 2025, my lord, we have received the instructions from Director of my lord fingerprint. Then my lord 3rd we have sent before the respondent number 4. That is my lord awaiting, my lord. After my lord getting my lord 2 reports, we can my lord.
When you will be able to produce the report from Central Fingerprints Bureau you have received. Now you have sent to the
the Central Forensic Laboratory.
Laboratory.
Kindly fix my time limit, my judicial order may kindly be passed. It will be my lord easier for us.
So why in all matters the judicial order is required to be passed? You obtain order or obtain report from CFSL.
Very well, my lord.
Central Forensic Science Laboratory you have sent.
Yes, my lord. Newtown. We have sent on 3rd December. 2nd December we have received, and on the next day we have sent.
What is the report so far? Fingerprint.
My lord, original report has been sent, so report has not been sent to me, my lord. Only my lord instructions I have received that they have received the report from my lord the Central Fingerprint and then sent to the my lord Forensic Laboratory.
Forensic Laboratory is party.
Yes, my lord. Yes, my lord. Respondent number 4, my lord.
So you are representing Forensic Laboratory.
Yes, my lord. My lord.
This one are 4.
4, my lord.
Issue. Mr. Ghosh, learned advocate representing Union of India on instruction submits that pursuant to the order dated 19th November 2025, Central Directorate, Central Fingerprint Bureau, National Crime Record Bureau, New Delhi, sent the report on 3rd.
On 2nd, my lord. 2nd
December 2024 to BSF.
To my lord, yes, my lord.
To Border Security Force, and said report was forwarded to CFSL.
My lord.
And the report and the said report, and on receipt of said report, same was forwarded to Central Forensic Laboratory, Kolkata.
On 3rd December.
On 3rd December 2025 for obtaining further report.
Obtaining for my lord handwriting and signature verification, my lord.
For obtaining
handwriting and signature verification.
For obtaining report after verification of handwriting and signature of the petitioner.
My lord.
Stop. Director, next paragraph. Director, Central Forensic Laboratory, Kolkata, being respondent number 4, is directed to forward the report by fortnight from the date of communication of this order to Border Security Force, as appointment of the petitioner for the post of Constable GD depends upon such report, and petitioner is one of the wait-listed.
No, withheld list.
With one of the candidates whose name is a candidate whose name is featuring in the list of withheld candidates. Next paragraph. Learned advocate representing the petitioner is directed to communicate this order to the respondent number 4 by 7 days from date. Stop. Next paragraph. List the matter under the same heading for further consideration on 15 January 2026.
Item number 4.
For the petition in this matter.
Yes, what is your instruction? You are appearing for the state response.
Report, my lord.
No, mayor filing report will not do. ফেরত দাও. Now it is petitioner has been terminated from service on 7 by dismissal order dated 17th October 2025. Now the basis of termination is involvement of the petitioner in a criminal case, that is Manik Chowk PS case number 443 of 2016, dated 19th October 2016. Petitioner submits that the authorities proceeded on the premise since one Imam Haq alias Imam Hussain was involved in the said criminal case, was implicated in the said criminal case, but said Imam Haq or Imam Hussain is not the petitioner. So what is the report to that extent? Tell me.
You know, these are same and identical person, my lord. Son of Sheikh Duggi, what I could recollect this, my lord. Sheikh Duggi, my lord. His actual name is, my lord, Tajimul Haq. These are same and identical person, my lord.
Who are same and identical person?
My lord, this Imam Hussain, my lord, son of Sheikh Duggi, as is in the FIR, my lord, and Imam Hussain, son of Tajimul Sheikh. My lord, these are same and identical person.
Yes, Mr. Lahiri, you demonstrated on last occasion that petitioner is not on what, based on which documents?
Yes, my lord. Kindly, my lord, first of all, I will show that page 32, this is the complaint. Complaint copy. Possibly Lordship had marked also. Kindly see Imam Hussain, Pita Sheikh.
At the middle, Imam Hussain.
Imam Hussain Sheikh Duggi.
Pita Sheikh Duggi.
I am Muhammad Imam Haq, that I have stated in page 21 in my application form. Page 21, son of Muhammad Tajimul Haq. Now, my lord.
Just page 21.
Page 21. Kindly see. Name Muhammad Imam Haq. Father's name Muhammad Tajimul Haq. Is the petitioner before your lordship.
My lord, the complainant in this.
Just a minute.
My lord, before adjudicating, my lord, may I be heard, my lord?
Please wait.
I am waiting, my lord.
Yes, Imam Hussain Muhammad Tajimul Haq is the petitioner.
Muhammad Imam Haq is the petitioner. Son of Muhammad Tajimul Haq. Now,
yes, Imam Haq is the petitioner. His father's name is Tajimul Haq.
Tajimul Haq. Now, my lord, kindly complaint copy Imam Hussain, son of
Duggi.
Now, my lord, in the FIR also, next page, same. Kindly, lordship, see the middle portion, right hand side, Imam Hussain, son of Sheikh Duggi. Next, my lord, kindly.
Page 37.
Page 37. No, page 37 is their report, which I am disputing. My lord, kindly come to page 44 once. Page 44, the Manik Chowk PS Malda gives a report.
When you were appointed?
I was appointed
22. 2020.
2023. 2023. I have appointment letter page 17. 28th of August 2020.
So it's a police verification report prior to appointment.
Yes, prior to appointment.
Okay.
Now, my lord, kindly see the court's record. In the bail order also, before the learned trial court, the name is Imam Hussain at page 43.
Page
43. Well, that person had obtained bail in that proceeding. Kindly see the last paragraph. Imam Hussain.
Yes, Imam Hussain.
Imam Hussain. Now, my lord, we obtained reports from the court itself, page 45 onwards. Kindly see. This is the official record we obtained from the court, page 45. Whether, question number 1, whether Muhammad Imam Haq, son of Muhammad Tajimul Haq, resident of village such and such, post such and such, Manikchok, PS Manikchok, district Malda, is FIR named in connection with above referred case being such and such. Question at right hand side, extreme right hand side, serial number no. Serial number 1, no. Question number 2, whether Muhammad Imam Haq, son of Muhammad Tajimul Haq, such and such, is charge sheeted.
Now the point is, there was a police verification prior to appointment of the petitioner. Now in the police verification report, which is
44. Page 44.
Which is at page 44. Come to page 44. You don't have the brief.
My clerk is not here.
No. Factual matters wholly based on facts, and without brief you are appearing. With a report from the police authority, please see the report. If this is the assistance the court gets, then it is difficult to adjudicate the issues, especially this kind, the issue, the nature of issue involved in this petition. First, state respondents were directed to appear. There's a notice, direction to serve notice. In spite of that, nobody appeared. Matter was adjourned, and today, state government, state advocate is appearing without brief. Come to page 44. Already there is a police verification because it's a case of 2016. Criminal case is of 2016. You will get the criminal case. I have recorded in my order. PS case number 443-216, 2016, dated 19th October 2016. Is Manikchok PS case number. Now come to page 44. Manikchok PS Malda, what they are saying, please read it.
Further verification, it is certified that no adverse record could be found. Muhammad Imam Haq, son of Muhammad Tajimul Haq.
Now, come to page 21. It is an enrollment roll and enrollment form of Border Security Force BSF. Page 21. Serial number 1, name of the petitioner Muhammad Imam Haq. And father's name Tajimul Haq. Come to the complaint. It is a complaint dated 9th October 2016, based on which this criminal case was initiated. 19th October 2016. Now it is complaint at the middle. Find out the name of a person, Imam Hussain, Pita
Sheikh
Duggi. Turns to next page. Turns on to next page. Page 33. FIR dated 9th October 2016. Against clause 7, details of known, suspected, unknown, accused with full particulars. Then 8 reasons for under clause 7 it is stated Imam Hussain 20 son of Duggi, Sheikh Duggi. So how it was subsequently reported at page 37 by the Superintendent of Police Malda, DIB Malda, that petitioner is the same person against whom he is one of the accused in that criminal case which was initiated in 2016.
The complainant has addressed a letter to the DG BSF stating that this person is the same and identical person.
Complainant?
The complainant in the Manikchok PS, Miller. That complainant, Miller, had addressed a letter to the DG BSF stating that these two are same and identical persons.
And based on which petitioner has been terminated. Now, I want a specific report with regard to identity of this identity of the petitioner as well as Imam Hussain, son of Duggi, who is involved in the criminal case, who is implicated in the criminal case, and whether the petitioner and Imam Hussain is same and identical person. That is the crux of the issue.
Kindly come to page 37 for once. Father's name is not mentioned. Page 37.
For which state's presence court felt is necessary.
Kindly goes to the report once. Milord, here it is mentioned that they have the DIB, Milord, had examined few witnesses, Milord, and they stated that this is the same person, Milord.
Then why this police verification report was issued? Page 44. Come to page 44. No.
Appointment.
It is after the initiation of criminal case in 2023 by the same police station, Manikchok police station, officer ASI Manikchok police station.
Well, that I have to take instruction, Milord.
Same police station, it's subject to further verification. It is certified that instantly no advance record could be found against Muhammad Imam Haq, son of Muhammad Tajmul Haq. And nowhere it is found that the name of the father is Sheikh Duggi.
Milord, no, the witnesses state otherwise, Milord. The local witnesses, Milord, they state otherwise, Milord. Milord, this person is locally known as Sheikh Duggi. And that's one of the reasons, Milord, this complainant has named the father name as Sheikh Duggi.
Based on hearsay, I will be terminated.
Yes, so do you have a copy of this report so that you can place the relevant part of this report?
Milord.
No, another copy you have?
Yes, Milord.
Yes, give me the report.
Last para, Milord. Examination of witnesses.
Who examined witnesses?
The DIB, the officer in charge of the DIB, Milord. DIB Malda. Even the complainant has identified, Milord, what the DIB is stating.
Complainant may have some vested interest.
I don't know what.
Which vested interest against the person.
Just a minute.
Sir, page number page number 31.
The same Manikchok case, our একটা report দিয়েছে। Manikchok case has
another report of
another report.
Yes. We don't know how that ASA is given, but that same Manikchok PS is given. That may also be taken into consideration. That was also taken into consideration. This is only kindly consider that, but other report, same marks.
Mother of the said petitioner, own name is Tajimullah, wife of Tajimullah.
Who is the investigating officer in the said case? But the case is pending. What is the present status of this case?
The next date is fixed for
because he will say that he doesn't know. He is not implicated in that criminal case. What is the present status of the criminal case of 2016?
Fixed for consideration of charge on 17th of February.
Consideration of charge. So therefore, the petitioner, if the petitioner is the same person who is implicated in the criminal case, he must have appeared before the investigating officer.
My lord.
So therefore, obtain a report from investigating officer.
There is another report. There is another
Subsequent
obtain a report from investigating officer.
Yes,
He knows everything.
My lord, that must.
There is a
It's the end of the matter.
Subsequent report from the same Manikchok case, my lord.
Subsequent police's subsequent report.
It is not required at all.
Manikchok PS's report he has submitted.
It's not required at all, because in the criminal case you are saying that I am not
the same person.
Same person who is implicated in the criminal case of 2016. Now, in support of such statements, certain documents are relied upon. Now, the thing is this: only question is whether you are implicated in the criminal case or not.
And who obtained bail also.
Already matter is fixed before the trial court for consideration of charge. Charge sheet has already been filed under 173 of CRPC. Now, because it is 2016 proceeding. Now, if that be so, then the investigating officer is the best person to clarify whether petitioner is the same and identical person or not. Who is the investigating officer?
Only one thing, my lord. My learned friend submitted another report. The ICA has said. Kindly see once one paragraph. Another report has been submitted.
I will not see anything. After this,
kindly see the
let the investigation come.
My lord, may I submit, my lord?
Voter entry was found. Kindly see for once. May I request once, my lord, since it's a factual matter. This next.
Yes, Miss Sinha. Who is the investigating officer? So far, the criminal case of 2016 is concerned.
Who is the investigator?
Rajkumar Mandal.
And my lord, the complaint said mistakenly name was given. Kindly see page 2. Mistakenly.
My lord, I am told it's Mr. Rajkumar Mandal.
What is his designation?
Yes, sir.
Volume.
Yes, sir. Yes, sir. Sub-inspector. Sub-inspector.
Sub-inspector of that police station, Manikchok PS Malda.
Yes.
My lord, may I submit, my lord?
Why you are
I require to be heard, my lord, because I am
at this stage it is not required. Whatever you have done, you have already terminated the petitioner.
But before in this court, my lord, I have come. I am answering respondent.
I will consider it.
Heard, my lord.
If it is found that the petitioner and
the only condition is, my lord, this is an appealable order, my lord.
Please hear this court. If it is found that the petitioner is the same person.
My
it is an appealable order.
This court should not go into that matter.
Should not.
My lord.
No. If there is a provision of appeal, then normally court do not exercise discretion.
That is what.
To entertain appeal. That does not mean that the writ court cannot entertain the appeal.
My lord can.
Since there is an appeal provision.
My lord can. But I need to be heard.
Yes.
I needed to be heard.
Very basis is whether the person is implicated in the criminal case. What your appellate authority will do at this stage? Your very basis is this, that the person was implicated in criminal case. Whether the person implicated in criminal case is the same and identical person as the petitioner, who is an employee or who is working under BSF, that is the whole issue. If that is proved, then everything goes.
Then nothing remains to be decided by the appellate.
So therefore, don't take this point, Mr. Counsel, that there is an appeal provision that a writ court cannot exercise its discretion. Normally, we do not exercise such discretion.
Yes, ma'am. That is what my contention was.
Yes, but writ petition is maintainable.
My lord has that power. Inherent power does my lord.
They say the voter list is different.
Yes.
They say voter list name is different.
Nothing is required. I want a report from the investigating officer.
Well, since
why you are going here and there now, Mr. Lahiri?
Because there is a dichotomy between their.
Yes.
In one report.
Yes, Ms. Sinha, who is the investigating officer? Rajkumar Mondol. Where from you are getting this?
From the FIR, my lord.
So in the meantime, there may be a change. 2016.
Yes.
Obtain instruction that who is the investigating officer.
Based on record, they cannot.
I want a straight report from the investigating officer, because this petitioner, if petitioner is implicated in the criminal case, he must have appeared before the investigating officer.
Whether he can override DIG's order.
Yes.
DIG
Court can.
Court can absolutely. Whether the investigating officer can
Yes.
override DIG.
Are you aware of? Are you in a position to apprise this court that who is the investigating officer?
Lordship, may I come back with instructions? Proper instructions, my lord.
Only thing court wants that who is the investigating officer.
Lordship, may I come back with instructions?
Issue.
They have already given it on writing, my lord. So I do not know whether there will be any difference, because the higher authority.
Very well. Not today. Come back tomorrow.
My lord.
Obtain
Some order, my lord. I am standing
obtain
here for 3
instruction.
days,
Obtain instruction that who is the investigating officer. Miss Sinha, obtain instruction that who is the investigating officer. Come tomorrow.
My lord, tomorrow I will not be available, my lord. I will be there in court.
Your presence is not required.
It is required, my lord, because I am the answering respondent, my lord.
If ultimately if it is found that they are same and identical person, then your order will remain.
Apart from that, I may have some other contest.
Please hear this quote. If ultimately it is found that they are not same and identical person, then question would arise whether your termination order will survive or not.
My lord, I understand, my lord.
At that juncture, your presence will be required.
My lord, I understand, my lord. State is accommodated, but I will not be accommodated. That is not fair.
Your accommodation is, your instruction is not required. When your instruction will be required,
I am the
you are always accommodated. Please don't quarrel with the court.
I am standing.
Since no order is being passed today, which will not inure to your benefit.
My lord,
Then I have to tell the additional Solicitor General appropriately. Yes. Please take your seat.
Report has been sent by SP.
Who is the investigating officer? Who is the investigating officer? I have seen this report.
Have you?
Don't waste court's time. Who is the investigating officer? Are you in a position to apprise this court?
Change also.
Tomorrow, inform this court that who is the investigating officer.
May I come back with instructions?
Yes. Matter is heard in presence of the learned advocates representing the parties. Stop. A report dated 11 December 2025, prepared by Superintendent of Police DIB Malda, is filed in court today and same is taken on. Next paragraph. Issue, next paragraph. Issue is whether Muhammad Imam Haq, mananda EMAM HOQUE, MD tarage, son of MD Tajimul Haq, TAJIMUL HOQUE, is now Muhammad Imam Haq, son of so and so, and Imam Hussain,
IMAM,
son of Sheikh Duggi. Sheikh Duggi.
Imam spelling is different. IMAM, not
IMAM. IMAM, son of Sheikh Duggi, are same and identical person, is same and identical person, or they are different. Is same and identical person or not? Stop. Petitioner in the present writ petition is MD Imam Haq, who has been terminated from service as it is found by the concerned or as it is found by the concerned authority of BSF that he is implicated in a criminal proceeding being PS case number 443/2016 dated 19th October 2016. Manikchok PS case code. Stop. Next paragraph. Learned advocate representing the petitioners, learned advocate representing the state respondents submits that the criminal case to be considered by the court, the criminal case is to be considered by the court on 17th. What is the date? Next date fixed?
17th of
কবে ডেটটা বলে দাও।
17th of February.
17th of February. Where it is stated?
27th February 2026.
Where it is stated in the report? Second page.
Yes.
Which paragraph?
First paragraph. Continuing that. First paragraph.
ওইটা দেখাচ্ছে ছোটটা, বড় বড় রিপোর্টটা।
On 27th February 2025.
2026.
On 2026. Yes, it should be 20. On 27th February 2026. Stop. Next paragraph. This court finds that investigating officer in Manikchok PS case number 443/2016 dated 19th October 2016 is in a position to apprise this court whether aforesaid two persons is same or identical person or not. Stop. Learned advocate representing Ms. Sinha, learned advocate representing state respondents, has paid for accommodation to apprise this court that apprise this court about the investigating officer in connection with the aforesaid criminal case. Stop. Hearing of this matter stands adjourned till Monday next, 22nd December 2025, for taking further instruction. Stop. Next paragraph. Client advocate for the state respondent shall also be at leave to obtain a report from the investigating officer before the next date of hearing.
I'll be relying upon their documents also. They have given all the Aadhaar card, voter card, everything. I'll be relying on that also. Grateful to Lord. Much obliged.
Item number 5.
Well, beg to appear on behalf of the petitioner, my lord.
Yes.
Pass over your lordship. My senior is engaged courtroom number 12.
But,
Who is your senior?
June Kumar Mukherjee, Roy Mukherjee.
on the last occasion also, my lord, they had sought for an accommodation. There is some overwhelming urgency, my lord.
Whether you will oppose?
My lord, what I was humbly, my lord, submitting, my lord, may kindly consider my limited prayer, my lord. But just here's the
Sir,
fact.
pass over, let Rai Mukherjee
My
come.
lord, may kindly, my lord, hear the facts, my lord, once, my lord.
I will hear you, but
And, my
not
lord,
now
kindly, my lord,
since the accommodation is paid
my lord,
for.
may kindly, my lord, keep it on Monday, my lord. So why I'll tell you, lordship, my lord.
Several matters
No,
are
this matter, my lord, is so urgent, but my junior was
tomorrow, today it will be taken up.
Yes, lordship. 10 minutes accommodation will do.
Third pass over.
Then, my lord, may kindly take it up at 2, my lord.
Ordinance
I
matters
have
are
a
there.
matter fixed at 1 o'clock.
At 2 ordinance matters. If you are not available, then you will be accommodated after ordinance matters. It will be taken up. Let me see.
But in that event, my lord, may it be taken up on Friday.
No.
अरे भाई खोले था उन्हें भाई हम प्रॉब्लम আছে
Yes, please call the next matter. Pass over. If you are engaged in other court, I will accommodate you.
Item number 6.
I am for the
respondent, my lord, as per your
The last occasion, your lordship directed to file the affidavit by
filing
I have
short
not
affidavit.
received any copy. My lord, relating to the recruitment of the CISF driver, just now he is handing over. My lord, the notification says
Oh, that matter.
yes, my lord. This is the
Yes,
my lord,
affidavit.
this is the trade
Affidavit.
submitted.
notification with regard to the trade test.
In which paragraph you have stated?
Regarding his certificate.
Yes. Regarding disclosing the reasons for declaring that petitioner is not qualified in the test.
Annexure R4, page 9, and here I'm
No, where you have made the statements.
Paragraph 8. Paragraph 7 and 8 both can take.
7, just a minute. In page 9, where
Yes,
it is
page 9.
page 9, where it is stated that without wearing seat belt, without fastening seat belt, petitioner started driving.
He stated that I have been told about the grounds
Yes,
for my
that is-
rejection, and thereafter he put another signature. You see, candidates who have left the ground that is matter. So he has put his signature that he has been told. Has been told about this.
Yes.
That notification I have handed over to your lordship. Kindly have a look at the trade test. There is a specific
Page number. Page number 10.
Well, first of all, I want to use an exception to this affidavit because there are some allegation as per the law. It is stage of examination.
Yes, trade test.
First, driving of LMV, light motor vehicles, 50 marks. Pass marks is there. Then heavy motor vehicles, marks is 50. Pass marks is there. And then the knowledge about the car, particular vehicles, that is also marks. Where is the, may I put this question to myself?
How does it help you?
Yes,
Because you drove the car without wearing seat belt.
Yes,
that is impermissible in terms of the relevant provisions of the Motor Vehicles Act.
Motor Vehicles Act. I want to.
So how this will help?
I want to.
Clause 11.5 will help you.
That is the violation of traffic. Here, no traffic.
Whenever you drive a car, you must wear seat belt.
I have never been allowed to drive the car. That is
where you have
sole
stated.
allegation.
Where you have stated in the
Yes,
petition.
Specifically, I have made this allegation. I just put the start key.
Yes.
Paragraph 7. That at the time of driving test, when your petitioner just on the key for starting the vehicle by pressing key of the vehicle and shift the rear gear of the vehicle, the respondent authority examiner asked your petitioner to get down from the vehicle. Specifically,
yes, rightly said, because you started the vehicle.
But there is a time. I should not.
Before starting, there is a specific statement. Before starting, you need to wear the you need to fasten your seat belt.
No, in the notification as well there is.
What notification?
Notification for the employment.
For that, no notification is required.
Yes,
we regularly tell our drivers
motor
wear the seat belt and then start the ignition.
No, my lord. My lord, I am your order is subject to the correction of your lordships. If I start a car in my house, there is no requirement for
you are not driving the car in your house ground. It was a
That's
driving
why
test.
I want to,
So it was,
make an exception of this.
You are not
affidavit
driving your
filed
car.
in the file.
You are not driving your car in the courtyard of your house.
All right, but
It was a driving test.
yes,
So therefore, you are required to follow the procedure.
yes, if I complete the test and they said that you are not wired the seatbelt, then I can understand. But here I just put the key and start. They get down from the car and rejected my candidature on that ground. I have not wired the seatbelt.
It is stated in paragraph 7. Accordingly, the petitioner started driving in reverse, but the said a motor vehicle inspector stopped the vehicle after reaching certain point as shown in map and asked the petitioner to get down from the vehicle.
Yes,
because you are not saying
that is why
wearing
the
seat
last
belt.
occasion they have
Shall I
produced
keep
the videograph that has
videograph?
not been
Shall I get the
produced.
videograph where he was starting and he was driving?
Malad, that is my instruction
So
of
why-
my client.
No.
Malad, I cannot improve that. Malad, I only can
He
that
cannot-
make an exception to this report because it is
That will not improve the
allegation is
position.
there, and I have violated
Only,
the Motor
this
Vehicles
is-
Act.
This is only to place on record the reasons relating to your failure in driving test.
Yes,
Nothing
I-
else.
Malad, that is
Therefore,
why
there is no question of any exception.
That is why I allege that this impugned order is non-speaking order. Here nothing has been mentioned. How I get the number, how much I get the number in the driving test, that has not been specified. This is a non-speaking order without assigning any reason, only driving non-qualified in the driving test. If I have not wired the seat belt and start the car and complete the test, then if they can reject it my candidature on that ground, stating that you have not wired the seat belt and drove the car.
Yes,
but that has not been done, my lord. That is my. I want to.
It is the post of driver in BSF.
Yes, my lord. That, not CISF, my lord. CISF. I want to use the exception to this affidavit filed by the respondent authority. It is my prayer.
Matter is heard in presence of the learned advocates representing the parties. Stop. Next paragraph. In terms of the previous order, dated 2nd December 2025. An affidavit, a short affidavit is filed. By the respondent number 5, affirmed on December 11, 2025, and same is taken on record. Next paragraph. At the next paragraph. In the affidavit filed today, it is disclosed in paragraph. It is disclosed that during driving test, Petitioner started the vehicle.
And my lord,
Started the light motor vehicle. Started the
Section
light.
194B of the Motor Vehicles Act says that the penal provision.
Started the light motor vehicle. By pressing key without wearing seat belt. As a result whereof motor vehicle inspector had to abort a BORT. Driving test, as driving a motor vehicle, a light motor vehicle without wearing seat belt is impermissible. Stop. Next paragraph. On learned advocate representing the petitioner has relied upon clause 11.5 of recruitment of clause 11.5 of notice relating to recruitment of constable / driver and constable / driver cum pump operator within bracket driver for fire services close bracket in CISF 2024. Wherein it is provided that who qualify in the physical efficiency test, physical standard test and document verification will be put through the following, driving test for light vehicle, driving test for heavy vehicle, and practical knowledge of motor mechanism and ability to carry out minor repair or vehicles. Stop. Any candidate who does not, it is also provided therein that any candidate who does not secure the minimum qualifying marks in these tests shown against each will be, now in these tests shown against each in these tests will be eliminated from that particular stage by issuing a rejection slip and will not be allowed to participate in the further recruitment process. Stop. Stop. It is contended that since petitioner was not permitted to complete driving, was not permitted to complete light vehicle driving test, question of allotting marks does not arise, and acts and actions of the respondent authorities are contrary to clause 11.5.1. Stop. Next paragraph. The provisions as contained under clause 11.5.1 does not come in aid of the petitioner as the petition, as the driving, as light motor vehicle driving test had to be aborted by motor vehicle inspector since petitioner started driving by pressing key without wearing seatbelt. So, next paragraph. Moreover, based on case made out, court was considering previously the document dated 12 November 2025, whereby petitioner was disqualified in driving test, does not bear reasons. But it appears that petitioner signed at the bottom of the said document dated 12 November 2025, certifying that he was told about the grounds of his rejection. Next paragraph. Since purpose of filing affidavit on behalf of respondents in terms of the order dated 2nd December 2025 is to disclose reasons as to why petitioner was disqualified in light motor vehicle driving tests, court finds there is no necessity to file exception to this report. সেন্টেন্সটা কি বলছে না? না, বাকিটা কেটে দাও। হ্যাঁ, filing of exception to this report is not called for, though prayed for. Stop. As it is, as it is averred in paragraph 7 of the writ petition, that when the petitioner pressed the key for starting light motor vehicle and shifted the gear, respondent authority / examiner asked the petitioner to get down from the vehicle, which corroborates the statements made on behalf of the respondents in the affidavit, which corroborates statement made on behalf of the respondents in paragraph 7 and 8 of the writ petition, paragraph 7 and 8 of the affidavit, which is filed today on behalf of the respondents. Stop. Nowhere in the writ petition it is averred that petitioner, after fastening the seat belt, FASTENING, fastening the seat belt, started the light motor vehicle during driving test. Stop. Therefore, calling for exception to this, to the affidavit filed today, will not improve the case of the petitioner further.
The Motor Vehicles Act does not show.
Next paragraph. Hence, no relief can be granted to the petitioners. The writ petition stands dismissed.
Deep level. But may I get back the notification?
Yes, you will get it back after putting signature. Yesterday's matter also, I directed my PA. You will get it back because there are certain corrections. That's why it was. Give it. Yes, next.
7.
Matter
relative family pension of unmarried daughter, Lordship.
Working where? Where employee was working where?
West Bengal State Electricity Distribution Company Limited.
West Bengal State Electricity
Distribution Company Limited.
WBSCDCL.
Yes. She retired in the year 89. And
now also, now you are also doing matters relating to WBSCDCL. Started doing matters.
Pension matter.
Yes. Yes, yes. What is the matter about?
Father died 27th December 2000. Thereafter, Lordship, mother died.
Family pension in favor of daughter, unmarried daughter. Yes, yes. Father died on?
Died on, Lordship, 27th December 2000.
2000.
2000. Mother died, Lordship.
When retired, father?
Retired 89.
Date?
Date is not mentioned, Lordship. In the year 89.
Date is not known. Then father was receiving pension.
Yes, Lordship. And
then mother, when mother died?
Mother, 8 April 2017.
8 April?
2017.
2017. After death, you are receiving, you are claiming pension.
Yes, yes, Lordship.
When he made application?
Lordship, immediately after death, but I have deposited the application. I did not have the copy, Lordship. But come to the page 27. First rejection order, Lordship.
So rejection order is there.
Yes.
Page 27.
Page 27. Got it, Lordship?
Judiciary Regulation 1985. Yes, 2021 order.
This was not challenged.
I have challenged. I am coming thereafter, Lordship. Thereafter, I have also applied family pension and I deposited the income certificate. And that also rejected, Lordship. Come to page 33.
No, it says that under judiciary regulation 1985, you are not entitled.
Therefore, also come to.
So therefore, the respondent authority did not request to submit documents. It was not due to failure on your part to submit documents. It says that under judiciary regulation, you are not entitled.
Lack of knowledge of petitioners. Obvious, maybe Lordship, the office told her.
Whether this was challenged?
Yes, Lord.
When it was challenged?
Next was Lordship, come to the prayer, Lordship.
Page 26.
So in this writ petition, you have challenged.
Yes,
2021 order.
Setting aside the memo dated, Lordship, both memo, Lordship.
After 4 years,
Yes, Lord.
already your claim has been rejected. So let it be decided on affidavit.
Again, rejected, Lordship.
Another rejection order is there.
Yes, Lord.
Where is that?
That is the page 33.
Previously regretted by letter dated 21st October 2021. It's not nothing but a reiteration of the previous order.
Yes, Lordship.
The claim upon review it is met the standards previously.
My income is, Lordship.
Why he petitioner will not get unmarried family pension being unmarried daughter?
2021, our regulation at that point of time, at the time of the death of the mother of the petitioner, 2,600 was the limit to be eligible to be granted pension. Now, that point of time, the document demonstrated by the petitioner that she was having 3,000 rupees. No, she was not eligible. That was communicated.
So mother was not getting pension.
Mother was getting pension, but the unmarried daughter.
Yes, maximum the income limit was 3,000.
3,000.
Now it has been enhanced to 9,000.
9,000. That is with effect from 2022. That amendment was made in the rule. Now she wants to have a retrospective effect of that particular. That is not permissible.
Retrospective effect
of the amendment of the rule. That was done in that 2022. 2021, she was not eligible because she was having 3,000 rupees. And admittedly, 2,600 was the limit. Yes, it was
2,600 was limit.
That
not 3,000.
Not 3,000. So that was rejected in that 2021. Now, after the amendment, now taking...
But that is not spelled out in the rejection order of 2021.
That is not spelled out. Now,
Now, what is the reason assigned? What is the reason assigned? Reason assigned is that cannot be accepted as per DCRB regulation 1985.
That is
because income cap was 2,600. And if it is above 2,600, then the candidate is not entitled to get. Now, where is the reason given?
That is not there. That is not there. I had a talk with my officers, my lord. That is not there.
No, nothing.
My lord, if you want, my lord, we can, my lord, give an elaborate, my lord, explanation for rejection of her claim. That we can do. Lord, you can direct, my lord, we can, my lord, supply. But my lord, the rule is very
clear. And the second communication dated 30th May 2025 is the reiteration of the previous order.
Because the case was being considered, my lord, on the rule.
Now it has been enhanced from 2,600 to 9,000.
9,000. That is with effect from 7th July 2022.
9,000. From 7 July
2022.
And rejection order loss of 2,000.
What is the present income of the petitioner?
Present
3,000.
So now petitioner is entitled.
But my lord, the case is being, my lord, taken note of, my lord, with effect from the death of the mother when she became eligible. The rule that was prevailing at that point of that was made applicable, and 2020 it was rejected. That was not challenged.
But if subsequently the family income, if subsequently income of the applicant is enhanced, it remains same, and the higher limit or income limit is enhanced from 2,600 to 9,000, why the candidate will not get eligibility? At that point of time, she might not be, might have been found to be not eligible.
Yes.
But now she is considering the enhancement. Why her case will not be considered?
Eligibility started.
Show me the provision.
Well, her eligibility started from the date of her mother.
Yes.
So, my lord,
court is not saying that you pay family pension during the period when the limit of family income was 2,600.
Yes.
But after enhancement with effect from 7 July 2022, why petitioner will not get?
Lordship, kindly may place, my lord,
Till
she is unmarried daughter.
Yes. Lordship, kindly see, my lord, page 19. Rule 19.
Also, I have annexed.
You have annexed?
Yes, sir.
Where it is?
Rule 19, I have annexed.
देखिए बोइटा दाओ.
Amendment also annexed.
Respect of pension. Yes. So unmarried daughter beyond, it is beyond the age of, age is above 25.
Yes.
Unmarried daughter beyond 25 years of age will be eligible for family pension subject to her income being less than 2,600 per month from all sources till marriage or death, whichever is earlier and thereafter. Now, if the income subject to the income being less than two, if the income limit is enhanced from 2,600 to 9,000 rupees, then subsequently petitioner should be made eligible.
But my lord, her eligibility, my lord.
No, that is not in perpetuity.
But my lord, in fact, my lord, the
court will not direct you to pay ADR benefits when 2,600 was the was the limit. But after enhancement from 2,600 to 9,000 rupees, petitioner is entitled to get.
No, my lord. So far, my lord, the amendment to the rule is concerned, my lord. The amendment, my lord, my respectful submission, my lord, will decide it, my lord. Whether, my lord, any amendment of the regulation, my lord, can have any retrospective effect or not.
Court will not give any retrospective effect. Court will give it prospective effect so far the payment of family pension is concerned.
Her eligibility arose on the death of her mother.
Yes, but that is not crystallized in view of the subsequent enhancement. It is not a case of appointment on compassionate ground. It is a case of family pension which is required to be interpreted liberally. What you are submitting?
True, my lord. But my lord,
it is not a case of appointment on compassionate ground, Mr. Chattopadhyay.
I appreciate, my lord. I appreciate what is following from my lord, my lord. But I had a talk with my officer, my lord. The difficulty is, my lord, in that event, my lord.
It's a beneficial scheme. It requires to be interpreted liberally. Otherwise, whole purpose of enhancing the limit from 2,600 to 9,000 will be defeated.
No, that will be made applicable, my lord, eligible, my lord, the persons who died after the, my lord, amendment came into effect. The persons who
think about the position.
There is no
that,
mention, Lord.
Please wait. Think about the position that from 7 July 2022, on 10 July 2022, if an unmarried daughter's family income is per month is 5,000 rupees, and another daughter's income is was 2,600 rupees or less than that. Both will get, but there will be another class of unmarried daughters that since their case was decided prior to 7th of July 2022, they will not get family pension. But similarly circumstanced other group of unmarried daughters or widowed daughters, they will get family pension since their entitlement was considered after 7th of July 2022 on the anvil of enhancement.
But my lord,
it doesn't make any sense.
No, true, my lord. But my lord, what?
And also in the state government, other department, you obtain instructions. This point is never urged after enhancement.
Let me come back on Monday. Let me take instruction. Let me come back on Monday, my lord. I'm getting, my lord, the points taken by your lordship, my lord. The difficulty is, my lord, in that event where the floodgate will open.
Yes, those who are entitled to get, they will get it.
My lord, let me come back.
Otherwise, the purpose of enhancing the limit from 2,600 to 9,000 will be defeated.
No.
And the court is not considering appointment on compassionate ground. That the scheme which was prevalent on the date of death, and now it is at the time of consideration of application after the law laid down by the Supreme Court, that will be considered. It is a case of pension, family pension. It has to be interpreted liberally. It's a beneficial scheme.
Let me come back, my lord, next month. Let me come back. I will, but definitely, I will, my lord, take instruction, my lord, as to whether, my lord, what is the situation in the other state government.
Ask Mr. Mukherjee. He regularly appears before the state government whether this point is taken in case of teachers and other employees, that after enhancement of family pension, after enhancement of limit, from the date of enhancement, eligibility is fixed or considered.
Let me come back.
What about the teachers? Same thing. It was previously 3,000, now it is 9,000, and those who had the income of 9,000 or less, they are getting pension after an enhancement.
But my lord, to become eligible, there should be, my lord, a cut-off date. Cut-off date is the date of amendment to the rule.
Retrospective effect can, yes, it does not have retrospective effect. That does not mean that from the prospectively it will not be applied. But court will not direct that from 2017 to 27th of July 2022 you will pay the arrear benefits. But from 7th July 2022, petitioner's entitlement comes.
No, my lord, the difficulty is, my lord, her eligibility, my lord, I'm sorry for repetition, my lord, her eligibility comes, my lord, after the
petitioner has affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner has claimed family pension being unmarried daughter of a deceased employee of West Bengal State Electricity
Distribution Company Limited.
WBSEDCL, just a minute. West Bengal State Electricity Distribution Company Limited, within bracket for short WBSEDCL, close bracket. Stop. Father of the petitioner was employee of WBSEDCL who died in 1989, who retired in 1989 and died on 27 December 2000. Stop. Father was in receipt of pension till the date of his death. After death of father, mother obtained family pension. Mother received family pension till her date on 8 April 2017. Stop. Petitioner being unmarried daughter of daughter and whose age is above 25 years is claiming family pension from the date following the date of her mother. Stop. Next paragraph. Mr. Supriyo Chattopadhyay, learned advocate representing WBSEDCL, submits that previously income limit was rupees 2,600 for adjudging an applicant whether to get family pension or not. Stop. From 7 July 2022, income limit, monthly income limit was enhanced from 2,600 to 9,000 rupees, 2,600 to rupees 9,000. Stop. According to the petitioner, according to the respondents, entitlement of the petitioner is required to be adjudged on the date of mother, that was on 8 April 2017, when income limit was restricted to rupees 2,600 and petitioner had income more than rupees 2,600. Stop. Next paragraph. Question arises for consideration that after enhancement of income limit, monthly income limit from 2,600 to rupees 9,000 from 7 July 2022, whether petitioner is entitled to receive family pension as her monthly income is less than rupees 9,000. Stop. Next paragraph. Mr. Chattopadhyay has prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on January 2026. Take it back.
I'm coming. Milord, the passed over matter, Milord, item number 5, Milord. Mr. Rai Mukherjee is here.